in order to perfect his ability to appeal, I filed the notice of appeal, and his intent is to have the public defender's office complete the appeal. During his time while he was incarcerated, the court initially appointed the public defender's office to represent him. At some point, their family hired Mr. Shaw and I to help finish off the case. And then I also had him complete because I noticed that the court just appointed the public defender. He never actually filled out an application. We filled out the application, sent it to the clerk's office, and just my paralegal wanted me to make this abundantly clear. Under number 4, where it says $2,300 twice, it's only $1,2,300. It's not $4,600.
Okay, when you said y'all filled it out, did he sign it?
He did.
Okay, do you have a copy of that?
I do, may I approach?
Yes, sir. Mr. Patel, in your motion it says cost twice, including in paragraph 3. So it says cost of litigating his appeal. So that was why I was running down that road.
I understand.
Okay, so to the state, any input you want to provide?
We have no input this time, Your Honor.
Okay. Based on Mr. Clear's affidavit, the court does find that he is indigent and that he qualifies for the public defender to represent him on the appeal. And as far as Mr. Clear being present, did you waive his presence?
I asked that if he had permission to come.
Oh, Mr. Clear, I'm sorry, you're on the phone, right? Mr. Clear, can you hear me? Mr. Clear, can you hear me?
I can barely hear you, Your Honor.
Okay. Mr. Clear, you wish for the public defender to represent you, and you stipulate to Mr. Patel and Mr. Gates withdrawing?
Yes, sir.
Okay. Then those motions are granted.
Judge, if I can approach with 2 proposed orders.
Yes, sir. Mr. Patel, with that being said, are there time periods that the public defender needs to be aware of, or have you preserved those?
I have preserved them. However, I have no problem getting with, I'll speak to Mr. McKinney and figure out who I need to talk to about getting all the information so everything can be done in a timely manner.
Okay, good. Mr. McKinney, anything you want to tell Mr. Clear?
Mr. Clear, can you hear me on the phone?
Yes, sir. You're kind of coming in with an echo, but I'll try to concentrate as hard as I can.
Mr. Clear, I work with the Public Defender's Office. I'll make sure that my office is aware of the appointment for the appellate purposes. And then you should receive some documentation, but we'll go ahead and make sure that everything is filed.
Okay.
Thank you, Mr. Patel.
Maybe excused?
Yes, sir. Thank you, Mr. Clear.
Thank you, Your Honor. Have a good day.
You too.
Thank you.
Okay. Yes, sir. Mr. Reed.
Yes, Judge. John Reed on behalf of Darius Wingate, who's incarcerated, Judge. And this is going to be a plea today. And Judge, for the record, this is Mr. Wingate. I provided him the plea agreement for his review while he was in the back. I'm just going to get him to sign it. Your Honor, if I may approach.
Yes, sir. Mr. Wingate, if you'll raise your right hand Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can put your hand down. So, Mr. Wingate, have you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, Your Honor.
Mr. Wingate, I do accept your plea. You're adjudicated guilty in both counts. You're sentenced to credit for time served in both counts. You'll need to pay the $515 in court costs, $100
Should be,
FDLE fee,
yes, Your Honor.
okay, and then $525
Drug offense fee.
drug offender fee, okay?
Sorry about that handwriting.
How long do you want to pay those, Mr. Wingate? How long do you need to pay them?
I don't know, sir.
6 months, is that enough?
Probably longer than that.
Okay, then you've got a year.
He's going to be incarcerated for probably another year. So I think it probably would be, at this point, beneficial to just send it to a civil lien.
And that is what we request, Your Honor,
Okay.
in the alternative.
Okay, so Mr. Wingate, you'll just go to a civil lien or judgment, okay?
Yes, sir.
Thank you, sir. Good luck to you.
And Judge, one further issue, not necessarily on the docket today, but Mr. Wingate does have an active warrant for new charges out of this county. He is currently serving a DOC sentence from a case in Walton County. He would like to get served with that warrant today, if at all possible. He does understand that that could affect his credit over in DOC, but he would like to get started with that case as soon as possible if it's doable.
Stay.
Judge, we believe that this is the best thing to be done on the case, is that he be served. I have the case number. It's 23 CF 241. It's homicide charges, Judge. We have depositions coming up in June. I think at this point, what needs to be done in the interest of justice at this point is that he be served, because at this point he is not entitled to any representation at the depositions with the co-defendants. So if there is no service on him, then there will be nobody representing him along this process while we continue to explore the cases.
Okay. So, Allison, how do we do that?
So we can't serve because he's in DOC custody. While he's at DOC, if we serve it, he is no longer going back to DOC, and he will no longer get time while he's here for what he's in custody for at DOC.
We are aware of this issue, and my understanding is that we had an opportunity to speak with Mr. Wingate, and Mr. Wingate was going to waive that issue.
Okay.
Yes, Judge, and Mr. Wingate has been fully advised of that issue regarding any credit that he may get for the DOC sentence.
This was above me. I won't be able to answer if it will be served or not.
Okay. So it's a policy thing, it sounds like. So I need to get involved and try to figure out from the policy perspective whether there's an administrative order or administrative directive.
We would ask that an order be entered by Your Honor that requires the court to serve this outstanding warrant on Mr. Wingate before he is transported back to
the court
DOC.
doesn't serve, so that you said for the court to serve.
No, for the court order to be served by the sheriff's office.
Right.
Okay. I'm fine entering an order that says that. So, Mr. Reed, if you want to prepare that proposed order.
I can, Your Honor, and it's my understanding that he's probably scheduled to be sent back or transported to DOC very quickly. Would there be an opportunity to keep him here for the time being while we get that order submitted to Your Honor?
I don't think I can, since he just entered the plea, there's no, I mean, I don't have jurisdiction, I don't think. That's my concern. I don't think I can just hold him any more than I can hold somebody else. If you can get me that order today, I'll sign it today.
We can, Your Honor.
Okay, good.
Mr. Wingate,
Mr. Reed, if you will, when you send it, email it directly to me,
Yes, Your Honor.
and then I'll make sure it gets done.
Thank you so much.
Thank you, sir.
That's all I have.
Thank you. Okay, what hearing do you want next?
Based on my triage, Crooks is the fastest.
Okay. Well, Ms. Dudley.
How you doing? Mr. Crooks is present, ma'am.
Hello again, Mr. Crooks.
Officially, I would adopt his motions for early termination of probation, and that he filed pro se.
Okay. And I did read through that. So, Ms. Dudley, do you want any evidence to present?
Just argument, Judge.
Okay, please.
Mr. Crooks has been dealing with two of the cases, the 2008 cases, since he was 17 years old. He is currently 32 years old. I know the court is aware of what he's wrote in his motions.
Yes, ma'am.
He is asking to terminate the probation. He has completed all his requirements. It's my understanding his probation officer at the time stated they had no objection to the termination as he has completed everything. He currently has a event promoting company, also does business marketing advertising. He also does volunteer community service with focus on excellence, which partners with Boys and Girls Club. He has done everything he can to move forward in his life since he's been 17. And I know he has made some violations, and he has admitted that in the paperwork. But he is asking that the court terminate his probation so that he can move forward with his life, so that he can continue to try to grow his business. He's limited at this point from traveling out of state to try to promote his business. So he is asking for the court to terminate the probation at this time.
Okay, thank you. To the state?
Your Honor, the state would respectfully request that this motion for early termination be denied. A little bit about this particular event. This event occurred while Mr. Crooks was on probation for a home invasion. He was seen on video on the instant, or the underlying case here. He was seen on video at a gun range firing and discharging a weapon. Given that the state had everything they needed to prove that was a felon in possession of a weapon, convicted felon in possession of a weapon. However, he was still given the benefit of the doubt, and we pleaded down to a lesser included offense of constructive possession to avoid that 3-year minimum mandatory sentence. And I think that's reflected, or that idea is reflected in the sentence, which was 2 years probation with a 3-year suspended DOC sentence. Given that, the state would respectfully request that this defendant be required to complete that term of probation as contemplated in the plea agreement, because he very clearly did get a pretty significant break in not being prosecuted for that felon in possession of convicted felon in possession of a weapon. For those reasons, we would respectfully request that this motion for early termination be denied, and that the defendant be required to complete his probation. I think it's through November. Thank you.
Thank you.
Your Honor, if I may.
Final? Yes, ma'am.
I was the attorney on that case, and in that case, the conversation I had with the state really came down to Mr. Crooks was not out committing crimes. He really thought it was okay for him to go to the gun range. And I think the court has seen probably numerous cases that have happened where people go to the gun range and are using firearms. However, he wasn't out using a firearm in public. He wasn't robbing anybody. He wasn't committing any other crimes. He mistakenly thought it would be okay. He went in there, he gave his ID, they let him come in, and he used the firearm, and he admitted to that. And that was a conversation I had with the state, that you had somebody who was trying everything they could to get through probation, being in the system since he was 17 years old, with no other criminal history. So that was the reason why the state agreed at that time, just because he wasn't out committing crimes with the firearm in itself. So that is, we still believe that he's completed everything. We still are asking that the court terminate probation. He does now know that he can't do that. We've had that conversation. I explained the law, because obviously the question was why they let us come in if that's the rule. And I explained, well, they don't necessarily check all that. So you have to be aware there are things you cannot do as a convicted felon. So we are still asking that the court terminate probation. He has completed all requirements of him at this time.
Thank you, Ms. Dudley. Mr. Crooks, as I was doing my homework, I printed off the sentencing recommendation. This was the one where you admitted the violation. I looked at the violation report, which was less than 2 years ago on 8/4/21, and that was the possession of a weapon or ammunition. So I'm glad to hear the facts of how that came about. Also looked at the violation report that was December 9th of 2020. So less than 3 years ago, possession of cocaine.
No, no, sir. 1 gram of possession of marijuana.
The violation report has possession of cocaine,
That's type of.
and then ecstasy and intent. Marijuana with intent to distribute.
No, those are for the last.
That may not have been what you were convicted for. Probation, help me.
Your Honor, on the case 21-1922, he does owe $1,079.52 cost of supervision that was imposed on 10/19/21.
Okay, thank you.
If I may, if you look at the original, I believe, probation, it said cost supervision was waived.
Not in this case, Your Honor. It's in the 2008 case it waived, but the paperwork that we have shows he owes COS in the 21 case.
Okay. Ms. Dudley, at this moment, I'm more concerned about the violation report that shows cocaine, ecstasy, and intent regarding marijuana, and then 2 year, and it seems like they're in two-year intervals. Violation report, one of them was in 21, the one before that, well, was 1 year before that in 20, the one before that was 2018. Aggravated assault with a weapon with intent to kill, discharged weapon in public, possession of weapon ammo by a convicted felon.
Your Honor, if I remember correctly, he wasn't found to have violated based on that. That was them thinking he was somebody else. In those cases, he wasn't prosecuted on those cases, and that's what he's saying at this moment.
Okay.
That wasn't. He's only violated and pled to the marijuana possession at that time for that violation. That's what he wanted the court to be aware of.
Good, and that's why I've raised it. I don't know everything, so
Yes.
I'm going to look at the docket.
Yes, sir.
Is that what the docket shows to the state?
I'm trying to look at that right now.
Thank you.
I don't see any of the charges with the possession of cocaine or ecstasy.
Okay.
On the Fulton, Georgia.
Yeah.
It's on the DOP dated 12/9/2020.
Right, that's the violation report. It's 08 CF 449 and 450.
Yes, he said that was out of state. It was in Georgia. He said those charges were dropped.
I would have no way of verifying it.
March 12th will be dismissed for that violation.
Excellent. Good, thank you, Madam. And what about the violation that was set forth in the report on 7/6/2018? Case number, oh, it's got warrantless arrest. Case numbers 08449 and 08450. Were those violations, the violation report was 7/6/18? Is that also dismissed? Thank you, ma'am.
What was the date again?
The date was 7/6/2018.
For the 2008 case.
Yes, ma'am. 449 and 450.
numerous times to track with the cases going to trial, so I'm having everything issue. Sentenced to 156 months DOC off in January 2019 for a VOP.
Okay, so the VOP in 2018, he was sentenced, and then he's on the probation based on that?
Because he took the term.
Ms. Dudley?
Yes.
Okay.
And I think he mentions that violation in there. I think it was the marijuana violation.
No, I do think it's just important to reiterate, he does still have a 3-year suspended sentence that's attached to the plea in this, so that's the main reason why we feel as though the 2 years should be fully completed.
Yes, sir. Mr. Crooks, based upon the seriousness of the crime, respectfully, your motion for early termination is denied, so you'll need to serve that out.
Yes, sir.
Well, Your Honor, with that being said and nothing else I can do, can we at least, do I have to write another motion concerning me changing it to an administrative type probation? Because the way I was understanding the law was that y'all would make a decision, and if y'all can't terminate me today, then the law said that y'all got to turn it to administrative probation. So I'm trying to figure out what's going on.
That we have to turn it into a...
You might, my bad, I said the wrong way. That you,
Okay.
you feel me?
I-
I'm just trying to, Your Honor,
Yes,
at this
sir.
time, I just want to get on with my life. I don't care about the probation. I'll pay whatever they want me to pay. I will stay on administrative. I just want to get out, visit my family, move around my business, and live my life. I've been stuck in
I
Okaloosa
understand,
County.
Mr. Crooks, but the probation started in 2018?
No, it started in 2008 when I got sentenced. I sent a 10 years DOC. I did
Right,
10
but
years.
then you
got
had,
out.
but then you had a violation, a significant violation in 2018.
No, sir, I had a 1 gram of marijuana. He's turned it from 5 years to 10 years, and that's how I ended up with 10 years of probation. If you were sentenced for an evidentiary hearing, I can get all this paperwork and bring it to you. Y'all have all this paperwork.
2022, the sentence, so the DOC
And the charges that he was sentenced for was just for marijuana possession?
No, the one that we're talking about now, he was sentenced on was for the possession of the weapon. That's what we were here on now. We weren't talking about a probationary period for marijuana. We were talking about the probation that stemmed from the charge of the lesser included offense of constructive possession of a firearm by a convicted felon.
I'm trying to figure out how a violation report, it says Terrence Walter Crooks, 7/6/2018, violation report, and it talks about violations that were aggravated assault with a weapon without intent to kill.
Right, that was one that was done well before this case that we were here on now. And I mainly was addressing this.
So the probation he's on doesn't relate to that.
It's the same probation.
They're running concurrent, I'm sure. I would have to go through and look.
Okay,
but
I mean, they're the same case numbers.
yes. I mean, to my knowledge,
Okay, let me just stop. They're the same case numbers. Based upon the seriousness of that, Mr. Crooks, your motion is denied. As far as a motion for administrative probation, if you want to orally make that motion, but I'm going to deny it. I don't think that's enough supervision for what the charges were.
Okay,
Let's talk about it.
Thank you, Mr.
yeah, I can't. There's nothing I can. I appreciate that.
Probation?
I just want to make him aware that $1,000 is due by July, because you're due to term in October. So 3 months prior to term, everything is paid off, okay?
got the paper right there with Judge Stone waived that $1,000.
Okay. Talk to Ms. Dudley and she'll advise you. Okay, you'll need to step away and talk to Ms. Dudley. Okay, next. Ms. Dudley, you also represent
Yes, sir.
Mr. Dawson?
Mr. Hughes, Judge.
I believe Mr. Hughes is here.
And
I
Mr.
don't believe
Lupello?
that Mr. Lupello represents him at this point. Mr. Lupello represented him originally. I don't,
Correct, I believe this was a pro se motion, or pro se letter that was filed. I don't believe this was filed.
Where is Mr. Hughes?
Mr. Hughes.
Mr. Hughes, come on up. No, sir. Not unless you're going to call her as a witness, and then you can call her when you want to provide evidence. Mr. Hughes' case is 21 CF 1451. Mr. Hughes, Mr. Lupello no longer represents you, correct?
Correct.
Okay. So I did read through your motion. You talk about $300 a month payment, and I can't afford that. You said that you can't afford $50 a month. You're permanently disabled. You're under Social Security disability. Talked about your wife going into surgery this month on the 12th. Well, has she already done that? That was April.
Yes, Your Honor. We've been staying in the car ever since about around almost 3 years now.
And I did see that it
Yes.
said that you lived in the car. If you'll raise your right hand, you swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you, sir. You can put your hand down. So, Mr. Hughes, is everything that you put in your motion, is it true?
Yes, it is, Your Honor.
Okay. What else do you want me to know?
My wife is the one that wrote the letter and stuff because I have cataracts now and stuff like that, and it's hard for me to see what I'm writing and stuff like that. But I like to have her as a witness there because she's my wife.
Okay, sure. If you want to call her as a witness, please, if you'll come up to the stand.
You can do first. Sure. Okay, come on this way.
You have to excuse me, Your Honor. I can't wear other clothes.
Okay.
Too swollen.
Yes, ma'am.
All right, please remain standing and please work the clerk.
Please raise your right hand. Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Mr. Hughes, questions for your wife?
You did write the letter and stuff like that about what was going on in that. And you what was pertained into it in that?
Yes.
Okay.
Anything else you want me to know from your wife? Any other facts?
Or she dealt with all the military stuff that has to do with my brother and stuff like that. And there's a colonel out there at the base there and stuff, gave her authorization and
Okay,
stuff.
this is time for you to ask her questions.
Okay, I'm
So
sorry.
instead of you testifying about what she would say, ask her the questions.
Okay, I'm sorry.
You're fine.
Is that what happened?
Yes, I did get permission from a colonel to go into all of the insurance and everything pertaining to your parents.
Right.
Okay. Mr. Hughes, so tell me why you're seeking, so you're seeking to reduce the monthly, are they restitution payments?
Yes, sir. Ours, I can't afford that. Ours.
Okay.
Ours.
Right. So is there anything else your wife can tell me about the money? You said you're living in your car?
Yes, sir.
Okay.
Ours. What do we have to do? Ours, while we're out there and stuff like that? We have to go to the doctors and stuff like that.
Yes, I've done had my surgery, and Ray's fixing to have a very big one, and we have to be in a house, and we have to afford a home. We had to sell our home and pay off. We finally finished paying our last note the first year, We sold a vehicle, and that vehicle belonged to Ray and I, ourselves. We saved our money because Ray had to ride a bicycle for 2 years after I had surgery. We lost our vehicle. And we took every penny of that, sold everything we owned whenever they sold the townhouse. His parents died, and we bought that little place, and we had to sell it because we couldn't live around older people or children. And so we've been living in a car since then. It's been mighty tough on 2 people disabled.
Yes, ma'am. So how much money do you have in the bank?
We have $100.43.
Okay. Any other assets you have other than your car?
No, sir.
Okay. And how much do you receive you and your husband receive in Social Security or disability each month?
Yes, sir, we both get Social Security disability. Mine was messed up a while back when they put me down as deceased, but right now I'm on $612, I think it is per month.
Okay. And how much does your husband receive?
$1,043. But we have responsibilities we have to have that because we don't have a truck to pay for no more. We have to pay a note. And so we have that insurance, and we have to pay what we have left in that we couldn't sell or didn't sell. We have to pay our fees on that for storage. Then we have to live because once in a while we have to go get a room to sort of relax.
Yes, ma'am.
And then we have to go get showers. That's $17 every time, plus driving all the way to the truck stop. I mean, it's a terrible life to live. But
Let me stop you a second. Does the state have any questions for Ms. Hughes?
What vehicle are you guys living in now?
we're in a 2018 Jeep Renegade.
How did you purchase that vehicle?
We had to sell our truck to pay for, try to save enough to get in a house.
Is it true or not that you guys used money that was taken from this incident to pay for that Jeep?
From this, what incident?
From this incident involving the exploitation of Mr. Hughes' brother?
No, Howard never had any money, to tell you the truth. We looked everywhere. All he had less than $1,000. Whenever he was in the hospital, that's when we had to use that money to pay for the lawyer. But when he was in the place where we had to go to the bank and get checks paid, Becky Nash at Crestview Manor, then we had to take whatever Mr. Fleet said we had to pay for Howard. We had to take what little bit he had left over of his check and add what we saved. And that's why it took longer to even put wood floors in our house. Or either I couldn't have surgery for 2 years and messed up my other leg really bad. So yes, sir, we've paid our dues, but we did not take any. Howard didn't have anything to take. If he did, his mother put it somewhere. I don't know where it is. We didn't associate that much. I just done the best I could to help get his parents buried, but we had a hard enough time as it was.
I have no further questions, Your Honor.
Thank you. Thank you, Ms. Hughes. You can step down.
Thank you.
Anything else, Mr. Hughes?
I think that should be it, Your Honor.
Okay. To the state?
Your Honor, I was not the attorney, the state attorney that was on this case. It was actually State Attorney Taylor Sharpless. And speaking with her and looking at the court record, if this court remembers, I believe at the time that we entered this plea agreement, a very similar discussion occurred in which Your Honor inquired about the fact that there had been a truck that had been purchased with the money that they had received as a byproduct of this incident, of this crime that had occurred. It was at that time, and it was contemplated into the plea agreement, that $300 would be a reasonable amount, and I believe the clerk's minutes even state that the state reserved the right to increase that pending any sort of financial change. And so I also want to point out in the letter that they sent in, they used money to pay for an attorney to defend himself for this crime. And I think it's not fair to the victim that he gets to see his money be used to defend themselves in a crime when it was his money. For those reasons, I think $300 is a reasonable amount. It was already contemplated by this court in taking testimony at the time the plea was entered. It was contemplated in the plea agreement specifically. We would request that the $300 remain the requirement to be paid.
Ms. Hughes, you've already testified, so you have to sit down. Thank you, ma'am.
Okay, thank you.
No, Mr. Hughes, I was talking to your wife. She was standing up.
Oh,
It's your motion, you get the last word. What would you like for me to know, Mr. Hughes? What has changed since the time that you were sentenced? What has changed financially between then and now?
well, Your Honor, in other words, everything. In other words, what my wife had to do and stuff like that was, when I was incarcerated in the jail and stuff like that, she had to sell that truck and stuff to get Mr. LaPella to represent me and stuff like that. Well, I served 45 days in jail without even having a bond or anything. And it was hard on me and stuff like that, and I've been very ill ever since then and stuff like that.
So did you sell your house after 2021, after this case was filed?
Yes, sir. Or after that, we had to sell that, the darn, try to find a place to live because everything started going up to rent $2,000 and stuff like that.
Okay. And did you owe a mortgage on that house when you sold it?
We paid it off.
Okay. So how much money, what were the proceeds from the sale of that house? How much did you get?
We got I think it was $38,000, $35,000.
And that was, when was that you sold it?
That was about 2 years ago, I guess, yes.
Okay. And what did you do with that money?
With that money there, I don't know, or it's, I don't know, Your Honor, or it's, I'm just all confused and everything else, what's going on and stuff.
Okay. Mr. Hughes, when you come in, when someone files a motion, they've got the burden of proof to prove what's required to prevail. At this point, I don't find that you fulfilled that burden. So respectfully, your motion to reduce the amount of payment from $300 is denied.
Well, how am I supposed to get up the money and stuff like that for doctors and stuff like that, co-pays and everything else there and that?
Yes, sir. I don't know, but because of the evidence that I've received, I don't believe there's a substantial change in circumstance that changes the amount of what you previously were obligated to pay. So I'm keeping the amount at $300 a month. Thank you, sir.
Thank you.
I think now we have Amy Sag,
Okay.
or Skaggs. Sorry.
Judge, I just had an opportunity to talk to Ms. Skaggs for a minute about this. At this point, Ms. Skaggs is coming in on her termination date, so that's why I think this violation got filed. She had some drug classes to complete. My understanding is she has one more meeting that she has to go to on Wednesday, and then she has one more payment that she'll have to make, and then everything should be done with probation. So at this point, what the state will request is to continue this until the June 12th date, and make sure that probation gets me proof that she's completed everything. So then hopefully if everything is done before the 12th, I can even file a dismissal of the violation of probation prior to that court date. But if not, then it will be on the books as a backstop.
Okay. So basically, continuance of the hearing until June 12th at 9 o'clock.
Yes, Judge.
Ms. Skaggs, you okay with that?
Mm-hmm.
Is that a yes?
Yes.
Okay. Then I'll see you back here on June 12th at 9 o'clock unless your probation is dismissed.
Okay.
Thank you, ma'am.
If we could have
Yes, ma'am.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call
Yeah, and my understanding it's gonna take a little while, so if we can have maybe 5 minutes to get the warrant service, so we can get that handled.
Okay, so we're in recess for 5 minutes. Thank you.
All rise.
850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Tom's Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Fat Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Thank you. It's a good judge.
I mean, I'll fill it out.
Yeah. So we're all like, well, what have we done wrong?
I just didn't know if you were gonna go back and look at this.
You done?
So I want to make sure that while you were here, you were
I
all
mean,
clear.
no, I
want to see this.
Yes, they will definitely. I appreciate it. It is Thursday.
I mean, that's fine. Just
Just leave it back.
Ready for me to just bring them out?
Yeah, you can bring them out.
Ready, John?
It just sounded good. You know what's crazy though is you could spend like $2 and buy a 2-in-1, 7-in-1 Head and Shoulders to go to the ocean and jump in.
I just do that at Dollar Tree. And then you're spending $1. Well, now, I guess it went up, so what, maybe
Just go
$1
through,
for
go to the ocean.
All right. Court is back in session.
Thank you, please be seated. Mr. Reed, thanks for coming back.
Yes, Judge, of course.
Okay. So I've got the caveus. Was also handed a form for first appearance for non-adversarial probable cause determination. Usually that's made before the caveus is issued, right? But we're doing first appearance?
We're doing first appearance on a grand jury indictment, Your Honor.
Yes, sir. Actually,
Because if it's from the grand jury, the court doesn't make that determination, right? court doesn't make a determination of probable cause after a grand jury, right?
That's correct.
To my knowledge, you're correct, Your Honor.
That's right. I end up doing it as just a direct issue habeas, so that's my apologies, Judge. I elected to just do the indictments with the code amendments.
Okay,
So here's the arrest warrant. Does Your Honor need to see the arrest warrant?
I can pull it up. We do have, who is on Zoom, y'all? Is it Miss Fisher? Joy Fisher? Miss Fisher, is that you on? Miss Fisher, can you hear me on Zoom? If you can, if you'll take your mic off mute. I don't know what she's here for. Yes, ma'am. What case are you here for? We can't hear you. What case are you here for? Okay. Can one of y'all talk over there closer to the mics and see if you can get her to...
Ms. Fisher, what case are you here for?
Okay, don't know. Okay.
Mr. Dawson, is she for you?
No.
No? Okay.
Okay. Thank you. Okay, so Ms. Davis, what are you asking the court for?
Judge, at this point, Your Honor had issued a warrant for Mr. Wingate's arrest. The way that it had originally been done was Your Honor signed it asking that he be treated as a juvenile. So it was a little bit strange. That was dated February 12th of 2022. At this point, Your Honor, he has been served with the warrant. We would like to proceed forward with first appearance, and we would like for Mr. Wingate to be held without bond on the charges.
Okay. Mr. Reed?
And Judge, I haven't had the benefit of taking a look at that arrest report of the warrant at this point in time.
Yeah, it's just a little thing.
And Your Honor, it does look like the court has issued the warrant itself. It's 103 pages or so. I haven't had the opportunity to go through that, Your Honor. But it is my understanding that based off of the issuance that the court has found probable cause at this point.
Okay, we have a direct issue capias. We're talking about 23 CF 241,
Yes.
right?
That is correct, Judge.
So I've got a direct issue capias. How would the court find probable cause based on a capias when there's no facts that are sworn to? I think you're not asking the court, I'm not aware of the court having to find probable cause, right? I just based on the direct issue capias, the court would issue a warrant. Okay? And I don't see a copy of the warrant either. see the capias. Mr. Reed, you talk about 100 and something pages. When I look at this docket, it only shows that there are 5 pages. 3 for the direct file, 1 for the capias direct file information, and then another one for the direct file capias. So I only see 5 pages. Are we looking at?
I may have seen a different document than you, Your Honor. I don't have anything currently. That's the issue.
Well, and the problem is something is wrong with the clerk's website that I can't see anything as far as any of the documents on the file. But I'm the assigned prosecutor, but I can't see any documents. Now, I have.
Right.
So I have, from our system, I have where Your Honor had signed off on the warrant affidavit, if you need to see that.
Well, right now, it's just service of the capias on Mr. Wingate, correct?
Yes, Judge.
That is correct, Judge.
Okay, so Mr. Wingate's been served, correct?
Yes.
Okay, then you want to do first appearance, and without Mr. Reed and I having the paperwork, it's kind of hard for us to do.
Do you want to hold them, I guess, until tomorrow morning, and we'll do first appearance with the normal first appearance judge?
Mr. Reed?
Judge, I mean, at this point, I think we'll probably have to. I personally am not going to be available for that, Judge. I have court in another county.
Right.
And just for the record, I'm not going to be representing Mr. Wingate on these new charges.
Okay.
So I'm sure he'll be appointed someone at first appearance.
Right. So, Mr. Wingate, you'll appear in front of the first appearance judge tomorrow morning. Then we'll have our ducks in a row a lot better. We were trying to push that rope as much as we could, but the system just didn't set up to do it the way that we were trying to do it. So you'll appear in front of the first appearance judge tomorrow morning, okay?
Yes, sir.
Thank you, sir.
Judge, may I have 30 seconds with this one?
Certainly. Yes, sir.
Do we know what time first appearance is in the morning? 8:30.
Ms. Davis, do you want any of these back?
No, Judge, those were.
They were from us.
Okay.
Thank you, ma'am.
Judge, that's all I have before the court. I can excuse.
Yes, ma'am. Thanks, Ms. Davis. Ms. Davis, thank you so much for coordinating all the different trials. I really appreciate it. Ms. Dudley, you ready? Thank you. Mr. Dawson's motion to suppress, correct? Good. Sir? Yes, sir. Thank you.
Yeah, I did follow an amended motion. I'm not sure if the court has a copy.
Okay, I don't think, I didn't see it.
I this morning because we just got the video this week.
Good, thank you. 21 CF71. Thank you, ma'am.
The biggest change is from the, I think, number 15.
Judge, do you need probation for?
No, ma'am, I don't. Thank you so much for everything. Thank you, Ms. Davis.
Your Honor, I'm just bringing in for now Officer Bukowski. We have 3, but I figured that Ms. Dudley would like to go through the rules, so I just, if you were going to stay back in the conference room.
Okay.
Set up cameras on.
So do you wish to call him as your first witness?
Yes, Your Honor.
Okay, please, if you'll come to the stand.
Am I free to proceed, Your Honor?
Yes, sir, please.
Officer Bukowski, can you please state your name for the record?
Sure, my name is Thomas Bukowski.
Where are you employed?
The Fort Walton Beach Police Department.
How long have you been employed there?
Coming up on 12 years.
Were you working on the night of January 7th, 2021?
Yes, sir.
Do you recall coming into contact with the defendant, Mr. DeMonte Dawson?
Yes, sir.
Did you have your body camera operating during that time?
Yes, sir.
Your Honor, may I approach the witness?
Yes, sir. Yes.
Officer Bukowski, do you recognize what I have just placed in front of you and it's marked as State's Exhibit A?
Yes, sir.
What is that?
It's a DVD.
Okay. Do you know what is on that DVD?
The body cam for the traffic stop.
Okay. And how do you know what State's Exhibit A is?
I've reviewed this previously.
Okay. And is that your signature that is located on that disc?
Yes, sir, it is.
Is that your badge number that's located on that disc?
Yes, sir, it is.
Did that video, when you were viewing it, did it appear to be edited or altered in any way, shape, or form?
No, sir.
Your Honor, at this time the state moves to admit Exhibit A into evidence and publish State's Exhibit A as well.
Any objection? No, sir. Yes, sir, it's admitted.
I have spoken with Ms. Dudley in regards to what will be playing on the video, and so I will stop at a certain point in time, but I've already spoken with her about that. I came early. I'm hoping the audio should work. I believe we got that figured out.
Yeah, the tent's a little dark. I think the background is good. The front quality is good. This is a ticket. Are there any like weapons inside your phone?
Strip's too low too.
Alright, so what I'm gonna do, I'm just gonna walk my dog around the vehicle back. Alright, so don't try to like whistle or get attention or anything like that.
Yeah, I got my hands up. I ain't got time for none of this shit here, dude.
I know you. So just don't do that. And see you guys hands at the ceiling.
It's even better, man. If you just want to put them up on the dash for me, that's even better. Okay?
Yeah, but that's kind of uncomfortable. I can let my feet up. Yeah.
No, just hang tight. It won't take that long. Just as long as I can see your hands, you're good.
Dude, 20 primary, over here, yeah, that's it. 10-4. This one's your closet, right? Come. You got a lot of perfect a lot of background stuff.
Smoke no weed, man, nothing. What's going on? It has nothing to do with weed, man. So that dog is not trained on marijuana at all. All right. So, man, what I'm going to ask you to do is keep your hands on the steering wheel for right now. I'm going to have you step out. When you step out, I want you to take your hands and put them right up here for me real quick. Do you have any guns on you at all?
No, sir.
I didn't ask you to do that. Okay. When you step out, put your hands right up here. Pat you down for weapons. Make sure you don't have any guns on you. Okay. All right. Push down. Okay. All right.
It's all right.
Here's what it is.
It's just a phone, sir.
Okay. Don't have no guns on you, nothing like that,
Sir,
right?
I swear I don't have shit on me, sir.
What's it? Is it a lighter or something?
You can put.
Do you mind if I pull it out?
Yeah, go on in there.
Oh, that's a lighter on a string or whatever?
Yeah.
Okay. All right. Put your hands on your back for me real quick.
Why are you cuffing me?
I'll tell you in just a second. You're not under arrest.
That's what I'm saying,
I'll
sir.
put you in handcuffs real quick. Right now, you're just being detained. Handcuffs can come off just as quick as they can go on, okay?
All right, man.
All right, step out now. Put your hands behind your back.
Trying to give me some cooch.
Wait, I feel you.
All right, why you?
I feel you, but, we still got a job to do. All right, do me a favor. Will you step over here with this officer?
Yes, sir.
You saying out the front of the car, man?
Crazy.
Hey, sir, I'm gonna put your phone right here.
All right. Hey, the one on the dashboard is mine too.
Okay. I'm just going to pat you down. The left hand is in front of my camera right here. Alright, so you notice how there's nothing on the ground over here, guys? Notice how there's nothing on the ground?
Yeah.
Okay.
So you can search. You can. What do I need to take off my shoes?
What's that?
I'm saying you saying there's nothing on the ground. I'm saying you can search me the car.
No, it's just from my experience in the past where, like, if I didn't search somebody, I just patted down for weapons. They, like, throw stuff on the ground, and they try to say that's not theirs, you know?
Okay, but my phone ringing, like, really, that's probably my girl. And I'm trying to, like, really, like,
okay, well,
she don't need to know I'm with her, kind of, and I need to answer the phone so she don't, you feel me?
Bro code, right? I won't tell her.
But what I'm saying is there any way I can just answer my phone? Like, because that's probably her calling. I just want to tell her, like,
I have a rule. I don't let people talk on traffic stops on the phones.
Okay.
It's a safety thing.
Okay.
All right.
I'll just make up something.
I'll make it.
I'll make up something. I'll think of something.
I'll make it quick, okay?
Yeah.
All right. So just sit tight, you guys.
You got a record? I do. How good this is about. Whoa, shit. Bruh.
Turn around quick.
Yeah.
I'm going to search you, okay?
Alright.
What was that connect to?
This is around
it's
my
like
neck.
like a lanyard thing?
Yeah.
Alright.
Hey, sir. What's your name, sir?
Dawson.
Dawson?
Yeah, he got it.
Is it Dawson your first name or last name?
My last name.
Your last. What's your first name?
DeMonte.
DeMonte. What would you prefer me call you?
It doesn't matter. What's going on?
Mr. Dawson,
Yeah.
did you know that you were sitting on what appears to be some methamphetamine?
No, sir.
You didn't know that?
No.
It was right in your seat where you were sitting.
Sir, I have nothing to do with that, sir. I've been down that road already. You can search me, whatever, sir. I don't have none of that shit, sir. I don't even. That's.
What do you mean you've been down that road before?
I have. You see my record?
I haven't had a chance
You need to look me up, sir. I've been in trouble before. I ain't.
For what? The selling and stuff?
Yeah, that's what I'm trying to.
Turn and stuff? Why are your stances? Why did you king?
Huh?
Why didn't your stances? Why did you think?
God damn, sir.
Don't make me put you on the ground, okay?
Okay.
All right. No, that was not your nuts. That was a bag or something. Why don't you stand some more? All right.
Home.
Officer Bukowski, I think we saw live video. You were present during the canine sniff?
Yes, sir.
Where did the canine alert on the vehicle?
The front passenger portion.
Okay. While you were observing the interaction between, I believe it was Officer Trujillo and the defendant, did the defendant ever consent to being searched?
Numerous times.
Okay. When Officer Trujillo pulled the alleged methamphetamine or picked it up off the ground, do you remember if the bag was opened or closed or?
Yes, sir. The top of the bag was wide open.
I have no further questions for this witness, Your Honor.
Thank you. Mr. Everett? Yes, sir.
Officer, were you present when the traffic stop was conducted? Were you present when the car was stopped?
I don't recall if I was there right when the exact second the vehicle was stopped.
At any point in time, was Mr. Dawson read Miranda when he was cuffed?
I don't recall.
You just watched the video. In the video, did you see if was he read Miranda?
Not by me.
When Mr. Dawson, you say he consented multiple times, he was handcuffed, correct?
I don't know if he was handcuffed every single time. We'd have to watch the video
You
again.
just sat here and watched the video. You just said you watched it. You reviewed it before now.
Unfortunately, I wasn't prepared for that question, so I didn't write down the answer to that question. But we can watch the video again if you need to.
I don't think we need to watch it. I think it was clear he was taken out of the car and put in cuffs.
Okay.
Okay. And when the first time he said he consented, he was saying he would take off his shoes. Wasn't that correct? You know what he just said?
I'm not sure. We'd have to watch the video again.
And then the second time, he's being questioned by Sergeant Chisholm, and he hasn't been read Miranda, and he's already being searched by Officer Trio. Isn't that correct?
We would have to watch the video again.
All right, I don't have any further questions.
No further questions, Your Honor.
Thank you. May this officer be released?
I have no more use, Your Honor.
You can be released now.
Thank you, officer. You're released. Your next witness. Mr. Gomez.
Officer Trujillo, may you please state your name for the record?
Anthony Ray Trujillo.
And where are you employed?
Palm Beach Police Department.
How long have you been employed there?
8 years.
Were you working on January 7th, 2021?
Yes.
In what capacity were you working?
As a street crime unit, canine handler.
Canine handler. Is your canine, what is the name of your canine?
Bane.
Bane. Is Bane, is he properly certified? When was the last time before this particular incident? I know that it goes back a little bit.
Yes, sir.
But when is the last time that before this incident did Bane go through the process of being going through all of the proper training and accreditation that he needed?
For this case, it would have been October 6, 2020.
On January 7th, 2021, did you come into contact with the defendant?
Yes.
Actually, let me back up real quick. Is Canine Bane, is he, what drugs is he trained to detect?
Yes, sir. He's trained to detect methamphetamine, crack cocaine, and heroin.
Okay, so he's not trained to detect marijuana?
No.
Okay. How did you come into contact with the defendant on January 7th?
He was a passenger during the traffic stop.
Okay. And how did that traffic stop arise?
A pulled over vehicle for a headlight out.
Okay. Did you perform a canine free air sniff of the vehicle?
Yes, sir, I did.
What happened during that free air sniff?
During open free air sniff, I positioned my canine on the back of the vehicle and proceeded to go in a counterclockwise motion. And as I was walking past the front of the vehicle, my dog showed a head snap, started bracking back to the front of the vehicle, and showed a focused response to the presence of narcotics.
On what side of the vehicle was that alert?
The front passenger side.
Okay. What occurred after the canine alerted to the front passenger side of the vehicle?
So there was 2 occupants in the vehicle, and they were both requested to step out of the vehicle.
Was any sort of pat down or search conducted at that time?
I got the driver out, and I'm not sure who got the defendant out.
Did you perform a pat down for weapons on the driver?
Just with the back of my hand, yes.
On the video that's on Officer Bukowski's body cam, you are seen searching the defendant later on, a little bit more. It was a much more thorough search. Why did you perform that search?
While we were searching the vehicle, we located several pieces of what we call shards, which are pieces of methamphetamine, and also the presence of narcotics alert.
At any point after the defendant was shown the shard of methamphetamine, did he consent to you searching him?
Yes.
Is it correct to state that you did not search the defendant until that shard of methamphetamine was found?
Yes.
To your knowledge, was there more than one shard of methamphetamine in the front seat?
Yes.
To your knowledge, was there any other shards of methamphetamine found anywhere in the vehicle?
Just in the passenger seat.
When you did search the defendant, what did you find?
A bag, like a sandwich bag, fell out of the defendant's leg pocket.
When you found that bag, was it open, closed, sealed? Do you recall?
It was open.
I have no further questions, Your Honor.
Yes, sir.
When you searched Mr. Dawson, had you read a Miranda at that point?
No, ma'am.
Did you have a chance to review that video before you came in?
Yes, ma'am.
All right. So what did you have a chance to review Officer Chisholm video as well? Or no?
No.
All right. So when you come in from the vehicle, you go and you tell Mr. Dawson you're going to search him, correct?
Yes.
And you start searching.
Yes, ma'am.
That's before he makes any statement about you just stated, he consented while you were searching. Well, you already searched him, correct?
Yes, ma'am.
And you did that search based on, you said there were shards of meth in the car and that the canine alerted on the vehicle.
Yes, ma'am.
And I believe at that time that those shards had not been tested, correct? Field tested.
Yes, ma'am.
Correct, they had not.
Correct.
And then there were two people in that vehicle, correct?
Yes, ma'am.
Mr. Dawson was the passenger
He
in
was
that
the
vehicle?
passenger, yes.
So your basis for searching was the shards that you said were in passenger seat and the K9 motor in the vehicle, correct?
Yes, ma'am.
And then after you were searching him, he stated you can search him when he was talking off Sergeant Chisholm, correct?
Yes, ma'am.
And at that point, you had not read him Miranda.
Yes, ma'am.
But he wasn't free to go, was he?
No.
All right, that's all I have, Your Honor.
Redirect.
I have no further questions, Your Honor.
Can this officer be released?
Yes, sir.
Thank you, sir. Be released.
Your Honor.
Next witness.
There you go.
Yes, sir.
This time around, the state calls Sergeant Chisholm to the stand for testifying.
Thank you, sir.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you.
Please state your name for the record.
Ryan Chisholm,
Where are you employed?
the Fort Walton Beach Police Department.
Okay, and how long have you been employed there?
12 years.
And in what capacity do you work for the Fort Walton Beach Police Department?
Currently, I'm the sergeant, the supervisor of the Special Investigations Unit.
Sergeant Chisholm, approximately how many cases have you worked on that methamphetamine was involved?
Likely in the hundreds.
Have you gone through field training and various types of training to identify methamphetamine?
Yes.
How often would you say that you come into contact with methamphetamine over the course of your experience as a police officer through your training?
Very frequently.
Were you working on the night of January 7th, 2021?
Yes, I was.
Did you have your body cam on that night?
I did.
No objection.
Your Honor, may I approach?
Yes, sir.
Sergeant Chisholm, I've handed you what I've marked as State's Exhibit B. Do you recognize that?
I do.
What is State's Exhibit B?
It is a disc that contains my body camera that I
And how do you know what State's Exhibit B is?
It has my signature.
Does the video that's on that disc appear to be edited or altered in any way?
No.
Your Honor, at this time the State moves to admit State's Exhibit B and publish.
No objection.
It's admitted.
223 crew detained 3 other criminals. Alright.
There's shards of meth on this seat. For sure. You searching really good? No, not really good. Alright, I'll search them really good. Yeah.
Sergeant Chisholm, I know it probably seems obvious from the video, but did you come into contact with the defendant that night?
Yes.
Okay. Have you ever come into contact with the defendant before?
I believe so.
Okay. When you arrived on scene, what first happened?
I, being the supervisor of the stop, my job is basically to watch the general scene. In this particular case, I was near the front passenger side of the vehicle while Detective Trujillo walked his canine around the vehicle, watching the passengers to ensure there were no furtive movements, things like that.
So you were present when the canine alerted to the vehicle?
Correct.
Do you recall where that alert occurred?
No.
Okay. After the canine alerted to the presence of narcotics, what did you do?
I asked Mr. Dawson to step out of the vehicle.
Did you specifically tell Mr. Dawson he was not under arrest?
No, I didn't.
Okay. Did you search the vehicle?
Yes, I did.
Okay. What did you find when you searched the vehicle?
Pretty standard vehicle, except for the methamphetamine shards that were on the front passenger seat.
Were those methamphetamine shards in plain view when you walked up to the vehicle?
Very much so.
Okay. Were there methamphetamine shards anywhere else in the vehicle?
No, just on the seat portion of the front passenger seat.
Do you think it would have been possible for anybody getting into that vehicle not to have known that there were shards of methamphetamine in the front seat or in the seat?
No, I mean he was sitting on them.
Okay. Can shards of methamphetamine be mistaken for other things?
Highly, highly unlikely. Not that I know of.
How did you know that that was methamphetamine shards?
I've seen methamphetamine hundreds of times. I mean, it was immediately apparent to me that it was methamphetamine.
Okay. After you found the methamphetamine shards, what did you do?
I continued searching the vehicle for the source of any other narcotics or other contraband in the vehicle. Once I had completed the search, I was told that they had found the methamphetamine on his person.
Okay. At what point did you develop the probable cause to arrest the defendant?
As soon as I saw the methamphetamine underneath him.
Okay. How did you develop that probable cause?
Clearly in possession of it, seated on top of.
Okay. Just so that the court is aware, are these the shards of methamphetamine? It might be tough to see from very far away from the TV, but are these the shards of methamphetamine that you were talking about here?
Yes, and I can point to them if you want.
Yeah, please do actually for the courts.
These here, this was a larger one.
I have no further questions.
Yes, sir. Sergeant Chisholm, when you took the defendant out of the vehicle, you cuffed him, correct? After you patted him down?
Yes, ma'am.
What was the point of putting him in handcuffs?
To restrict his movements.
Why?
Standard procedure to ensure that no one runs away from us, no one attempts to fight us. At that point, he was detained.
Did he give you any reason to think that he was going to fight you?
No, most people don't.
Okay. When you searched the vehicle, you used the flashlight, correct? So you could see in the vehicle?
Yes, ma'am.
Because it was dark outside? Tell me, when you searched the vehicle, when you found the meth, what you said is meth shards, did you tell me how long had Mr. Dawson been in the vehicle? Do you know?
I'm sorry, so
Do you know how long he had been in the vehicle before the traffic stop?
prior to our stop?
Yeah.
I have no idea.
Do you know what was on the seat when he got in the vehicle?
No, ma'am.
Did you field test the meth shards, that what you said is meth shards, before he was searched?
No.
Your basis for the search, I believe you stated you had probable cause to arrest him for the meth shards, is that correct?
Yes, ma'am.
But you hadn't field tested it, correct?
I know it.
I understand you saying you know math, but you hadn't field tested it, did you?
Correct. No, I did not.
All right. And you testified that it would be, basically anybody should know it's meth when they sit in a car?
Anyone who's familiar with the sight and texture of methamphetamine, yes.
So how do you know that at that time when you searched him, how do you know the defendant knew what was in that seat?
I didn't search him.
Or at the time he was searched, sorry. At the time
Everything
he was searched, what evidence do you have to say he knew what those little white pieces were on the seat?
I can't tell you what he did and did not know.
Exactly. Before he was searched, had you read him Miranda?
No, ma'am.
And there are two people in the car, so you saying because he was the closest, or are you saying sitting on the, what you say is meth charts, that's why you arrested him, correct? Or had probable cause to arrest him?
Yes.
Did you ever collect the meth shards and test them?
I did not test the shards that were in the seat. I tested the shards that were found on his person.
But you didn't test the shards that you said you had probable cause to arrest him for?
Correct.
And why do you generally do a field test?
To confirm the presence of a illicit drug.
To make sure that it is what you think it is, correct?
Yes.
I don't have anything else now.
Yes, sir.
Sergeant Chisholm, you said you did field test the narcotics that were found?
Correct.
And they did field test positive for methamphetamine?
Yes, sir, they did.
Okay. And the bag was open when it was found on him? Thank you. I have no further questions, Your Honor.
And the sergeant be released.
Yes, sir.
Yes.
Thank you, Sergeant. You're released. Thank you, sir.
Your Honor, that's all of the state's witnesses at this time.
Okay, thank you. Ms. Dudley, any evidence?
No, sir. Just argument.
Argument?
Yes, sir.
Ms. Dudley?
Yeah, if I may argue from here?
Yes, ma'am.
Yeah, in a motion, I filed the motion based on a couple of things. But the biggest part is obviously that the basis for the search. We've had Sergeant Trujillo testify that the basis for the search was a K-9 alert on the vehicle and because of the meth shards found in the vehicle. We had Sergeant Chisholm testify that the search was based on probable cause for an arrest for possession of what he says meth shards. It should be noted that there are two people in the car, so we dealing with constructive possession. Any area that is jointly occupied, we're dealing with constructive possession, and the area in the car was jointly occupied. Sergeant Chisholm testified he doesn't know. He can't say what Mr. Dawson knew and didn't know, and part of probable cause for a possession is knowledge, dominion, and control. You must have all three, not one or the other, especially in a double occupied vehicle. We also, the first thing I'll address is the K-9 alert part of Officer Trujillo's basis for searching In State v. Griffin, which is the first DCA case out of Okaloosa County, the first DCA ruled a canine alert on a vehicle is not a basis to search the person. So that is not a basis to search the defendant if just because a canine alert is on the vehicle. It is an exception to the warrant requirement for the vehicle only because the vehicles can be moved readily. So then we're left with the PC based on probable cause. Or in my opinion, the evidence shows no probable cause. So I've listed several cases in my motion. But I do have one, Presley v. State, 712 Southern 2nd, 1240. It is a 4th DCA case from 1998. 2 passengers inside the vehicle. The defendant, I believe, was a driver. In the seat, in the edge of the seat where he was sitting, in the seam of the driver's seat, there was cocaine. There was also small amount of residue and seeds also on the floor of the car. The defendant then told him he thought the substance was something else. The court ruled that the state failed to prove that he had knowledge, dominion, and control over those items because they're in a jointly occupied vehicle. And that is the same here. You have a jointly occupied vehicle where Mr. Dawson was actually the passenger in that car. I also should note that it's dark outside. He also has to use a flashlight to illuminate so he can see inside the vehicle. The officer says anybody gets inside the vehicle should know that it's meth. But then he says that he can't say what Mr. Dawson knew. He can't say how long Mr. Dawson was in the vehicle. He can't say if it was there when Mr. Dawson got in the vehicle. He can't say any of that. In order to have probable cause in a jointly occupied vehicle, he must be able to say how Mr. Dawson has knowledge and control in order to establish probable cause. Because that was the basis, probable cause for the arrest, for a possession that he never collected the items and never tested the items, and that's the basis for the search. Because otherwise, how do you get a search of somebody who you've detained? Let's see. One in Brown v. State, 313 Southern 2nd, 52. There's a 4th DCA case in 1975. In that case, there's marijuana seized throughout the vehicle. And that court states that the state has to prove if the marijuana seeds were in there before he got in there. How did they get in the car? You have to prove the defendant knew they were in there. And in that case, just because the marijuana seeds in the car, that still did not give them evidence to say that this passenger knew these items were inside of that car. Because we're dealing with constructive possession. All the case law cited, plus Renard v. State, Murphy v. State, that are cited in my motion, proximity alone is not enough. That's what we have here. He's the closest to the drugs because we're talking, and we can see the video. Well, I'm not saying you can't see little white things on the seat. They have to prove that the defendant would have known it was meth. Knowledge, dominion, and control. All three. And you have to show and deal with dominion and control whether or not he exercised control over those items because it's a jointly occupied car. And I've cited cases where the person is actually sitting on cocaine and marijuana seeds, and the court still said it's not enough. You got to be able to say the person knew it was there. It's not as if it's a big container you're sitting on and a clear plastic bag you're sitting on and you can still try to argue it, but you're still in a situation where you have to prove they knew what was in that bag. And they have to prove that he knew what was in that in order to get probable cause. Probable cause requires at least something of each element of the crime, in our case, knowledge, dominion, and control. When we're dealing with the fact that Mr. Dawson states he consents, so Officer Trio says as he's searching him, Mr. Dawson consents to the search. Well, he's already been searched. He's being questioned without Miranda, which means any statement he made says he's detained. They said he wasn't free to go. It didn't read a Miranda. And if you're going to ask him questions, you're required to read Miranda. And Sergeant Chisholm, when he's talking to him, and Mr. Dawson says, "You can search me," he hasn't been read Miranda at all. But I think I actually think that's somewhat irrelevant because he's already been searched by Officer Trujillo at the time. You can hear on Sergeant Chisholm's video when he says, "Oh, there are meth sharks on the seat." Officer Trujillo says, "Did you search him thoroughly?" He said, "No, I didn't." "Well, I'm going to go search him." And then you can see on Zabowski's video, he goes and searches him. And he says, "That's when I search him." And he says, "I'm going to search you." At that point, he's initiated that search. And he turns him around and he starts searching him. And I do have some cases I didn't cite because I just got that video, but it deals with consent while being in handcuffs. So Ballinger v. State. It is 2nd DCA, 16-7 3rd. Time to approach on, please. And I'll grab them both. In Ballinger v. State, the 2nd DCA, 16-7 3rd, 10/22, 2009. And in that case, it deals with the defendant being handcuffed. And it also deals with him being cuffed at all after being patted down. It talks about the basis for actually cuffing him in the beginning, which is why I asked Sergeant Chisholm that, what was the basis? Well, he just says it's standard. But Mr. Dawson wasn't on arrest, he was just detained because of the canine alert. In that case, the court talks about that while they're handcuffed, obviously the burden on the state is higher to prove that any consent is valid in the court. Obviously it's harder to prove that when somebody's actually handcuffed. It also talks about once the pat down was done, there was no threat to law enforcement because they didn't find any weapons. And that the fact that there was no reason to place handcuffs on that defendant. She had given no reason for them to believe she was a danger and no reason to believe that she would be violent. They also talk about the consent was not valid because she was handcuffed. It says whether or not a consent is voluntary comes down to totality of circumstances. It's the state's burden to show that the consent was freely and voluntarily given. But if there's an illegal search or an arrest or detention, then consent is involuntary. Unless you can show a break in that illegal arrest or search and the actual consent given. Here, Trujillo searches him, and as he searches him, he said, well, yeah, he consents while I'm searching him. So there's no break in that. And in Thomas v. State, Your Honor, I provided that to you as well. It's 1st DCA, 127, 7 3rd, 658, from 2013. It talks about the burden on the state to prove any warrantless search, the burden on the state to prove that it was valid. However, where officers get consent while they are either conducting an illegal search, illegal arrest, or illegal detention, the presumption is that the consent is involuntary. And it is a state's job to prove that this consent was voluntary. And of course, it once again states there has to be an unequivocal break from the illegal act to the actual consent. And in this case, I've given case law showing that the courts talk about saying they didn't have a basis to handcuff him. The basis for the search was a canine alert and probable cause for something that they had no probable cause for. And canine alert cannot be a basis to search a person. So we're asking that the court suppress the evidence and all statements found after Officer Trujillo started his search upon the defendant.
Thank you, Mr. Chairman.
Yes, sir.
Mr. Gomez?
There's a lot, so I'm going to try to kind of lay out. So first, the state, just as a general note, we're asking for this motion to be suppressed. First and foremost, the defendant consented multiple times to the search. One of those times was actually when he was taken out of the vehicle and Officer Trujillo was just looking on the ground, minding his own business and just looking on the ground, and the defendant said, he didn't say you can search my shoes, he said you can search me. He volunteered that, and that was they had just moved into the back and they had patted him down for weapons, and Trujillo was looking on the ground. You can see it in the video. I believe it's at the 550-ish mark, and the defendant literally says, you can search me, trying to dispel any suspicions officers might have, and he volunteered that consent. So I just want to make that's the first kind of prong as to why this motion to suppress should be denied. The second is because the state feels as though probable cause was established. The timeline of events and all of the officers testified that this was a traffic stop that had occurred, and then a free air sniff was conducted on the vehicle. When that free air sniff came back as an alert, then the defendant was asked out of the car and they were patted down for weapons for officer safety, and he was specifically told that he wasn't under arrest, it was on the video, and that he was simply being detained, and the handcuffs could come off as fast as they could go on. And then he was moved to the back. No further searches was done at that time. It was not until the shards of methamphetamine, which were in plain view in the front seat of the vehicle, and plain view is very important when you're talking about constructive possession, the plain view methamphetamine shards were found in the front seat of the vehicle and then taken to the defendant. At that time, if we're going to talk about the break kind of discussed in time with the second consent to search, I admit he was getting partially searched when Officer Chisholm walked up to him, but you have to understand, at that moment in time, Officer Trujillo was on the opposite side of the car when Officer Chisholm saw the methamphetamine shards in plain view. You don't have to read a defendant Miranda to search them once you've established that probable cause. At that point in time, once they see the methamphetamine shards in plain view in only the passenger seat, nowhere else in the vehicle, only the passenger seat, that right there was the moment the probable cause was established, that they could have arrested the defendant at that time, and then everything that they found after would have been search incident to arrest and under the inevitable discovery doctrine. So I just kind of wanted to lay out that timeline. That was when Trujillo goes up. He didn't need consent to search at that time. And while he was doing that, there was a break. Officer Chisholm comes up and actually says, were you aware that you were sitting on what appears to be a shard of methamphetamine? And the statement that the defendant made, I don't want to say it was verbatim, but it was something to the effect of, I don't have nothing, he looked at it, saw what was in his hand, I don't have nothing to do with that, sir. I've been down that road already. You can search me, whatever, sir. I don't have none of that shit, sir. Excuse my language. So not only did he voluntarily consent, because right once he sees the methamphetamine shard, he immediately consents to try to dispel suspicion of law enforcement officers, he also states that he's been down that road, and he admits to Trujillo before he searches him the second time that, yeah, I've sold some drugs, I've done that. You know, you looked at my record, and that was when Trujillo was like, I hadn't until you just said something. So that also goes towards the knowledge of the substance that was in the front seat of the vehicle that they had before they searched him the second time and found the alleged trafficking weight of methamphetamine. So I just kind of wanted to lay out what had happened and how it occurred. As for some of the cases that were mentioned, I'm going to kind of try to go a little bit in order. One of the ones, I didn't quite hear the case site on the very first one, but one of the ones was State v. Brown. And in that, the court is very clear that one of the reasons why they didn't find probable cause was created was because there was not proximity and plain view. I agree with the defense's assertion that mere proximity does not establish probable cause. However, when that methamphetamine is in plain view and you have the proximity and In this case, it's exclusive possession because that methamphetamine is only on the passenger seat of the vehicle. It's not in the driver's seat of the vehicle. It's not in the back seat. It's not in between the center console. It is on the driver's seat of the passenger side seat of the vehicle. That then creates that exclusive possession that we're looking at. He known or a reasonable person would have seen the shards of methamphetamine, and he is sitting on top of it. It's the definition of proximity, and as well as the plain view of the shards are just all over the seat. I think one of the cases that I want to cite, it's State v. Robinson. It is 27 Southern 3rd 137, and I do have a copy of that. And I actually highlighted the portions that I kind of want to bring up because it does speak a little bit to this issue. In this case, the court in Robinson actually contemplates a couple of other cases. And they said, in Giles v. State, police found drugs located in the opening of the driver's side door. Giles was the driver, but he had a passenger. The Giles court said that mere proximity to drugs is not enough to infer constructive possession, but the proximate location, coupled with the plain view of the drugs, is sufficient to meet the elements of a constructive possession offense. In the present case, the drugs were in plain view on the floorboard of the right rear passenger seat where Robinson was seated. The drugs were at Robinson's feet and were within his reach before he stepped out of the vehicle. The evidence is sufficient to establish probable cause to believe that Robinson was in possession of the drugs and to arrest him for it, and as a result, the trial court erred in granting this motion to suppress. This is extremely similar to the situation that we have here. They didn't go after the passenger, and in this case, the cops, law enforcement, didn't go after the driver. If this was the driver and it was found on the other side, then I get it, because it's just mere proximity. You may not even be in plain view to be able to see it. But given that he was literally sitting on top of the methamphetamine shards, in the exclusive possession of those methamphetamine shards, that is what establishes that probable cause and that constructive possession to allow them to A, arrest the defendant, and also B, search that defendant subsequent to any lawful arrest. I also have another case, and this is more, I didn't highlight anything because this is more of a general case. This is Upshaw, State versus Upshaw, and this is 251 Southern 3rd 1015. I'm actually in the court now. In this case, and this is also somewhat on point, in that case, law enforcement officers observed that it was in a high, they were patrolling an area, and they actually observed marijuana and cannabis shake inside of the vehicle, but nobody was actually in the vehicle. About 15 minutes later, the defendant then entered the passenger side of the vehicle while a woman entered the driver's side. The officers stopped their vehicle. They went for a pat down of the occupants, and at that time they didn't feel any weapons, but they did feel something in his pocket that they suspected to be drugs. When they reached into the pocket of the defendant, it turned out to be MDMA, a controlled substance. In that case, it stated, and I think it kind of is in head note 1, 2, and 3. The inevitable discovery doctrine requires that the state establish that the police ultimately would have discovered the evidence independently of any improper police conduct by means of normal investigation measures that inevitably would have been set in motion as a matter of routine police procedure. To determine whether there is probable cause to arrest on a constructive possessions theory, the state must establish that the arresting officer reasonably believed that the accused had dominion and control over the contraband and knowledge that it was within his presence. In that case, they go on and actually talk about the Robinson case that I cited, and then they go on to talk about how that was where the defendant was at. When they got into the car, they had to have seen the marijuana be there in the car, and for those reasons, they considered that to be a valid constructive possession, and they did not suppress the evidence found. I think that those two cases are extremely on point here because the shards of methamphetamine are exclusively within the control and possession and the knowledge of the defendant because it's only on his seat. It's not anywhere else in that car. So to try to make the argument that it was the driver's when it was only in the passenger seat just doesn't fly. And furthermore, with it being in the front seat directly under the defendant in plain view, it's one of those situations where the defendant had to have known that was there and that satisfies the knowledge and control elements of constructive possession. I'd also like to talk, there was some cases cited by the defendant, State v. Renard, for example, and I just kind of wanted to point out a little bit of the distinguishments and the differences between those cases and our case here. Importantly, in State v. Renard, and this was a case that was cited by the defense, it's 675 7th 2nd 1006, and I don't have a copy of that, Your Honor, I apologize. In that case, found on page 2 of the printout, or 1008 via the site, it states that the only paraphernalia located close to the defendant was found under the driver's seat by the transmission hump. One of the investigating deputies testified that the paraphernalia would not have been visible to somebody sitting in the front passenger seat. None of the deputies testified they had any reason to believe that the defendant knew of the presence of the contraband in the vehicle, and that mere proximity to the contraband does not create probable cause of constructive possession. In that case, very importantly, you have the paraphernalia that was used to establish probable cause was on the other side of the car, and there was no way that a defendant could have seen that. Here, we've had an officer testify. They were in plain view. A defendant would have seen that, and a reasonable officer would believe that the defendant would know and have knowledge and control and possession of the methamphetamine shards that were in the seat. Another one that was, I believe, cited by the defense was State v. Katie, which is 817 2D, or 7th 2nd 948. Similar thing, evidence that the defendant was the passenger in a vehicle where drugs were found under the driver's format did not give probable cause to an arrest, because the defendant was based on actual, or the defendant based on actual or constructive possession of drugs, and this is important, whereas the driver was subject to independent police investigation for narcotics. So in that case, a case the defense cited, the driver, the court found in that, the driver was subject to that independent narcotics investigation because the drugs were found under the driver's side format, creating that knowledge, dominion, and control that is needed for probable cause. Your Honor, I think by going through the cases that I've gone through and distinguishing some of the major cases that were cited by the defendant, in that was underneath our defendant in this case, it was not anywhere else in the vehicle, and given the fact that when the defendant was searched, the bag was open, it leads you to believe that their shards of methamphetamine came directly from that bag. Given the fact that not only did the defendant consent to a search twice, once was well before any sort of illegal detainment occurred, it was when Trujillo was looking on the ground and the defendant said, "What are you doing?" And Trujillo said, "I'm looking on the ground just in case anything falls out." He goes, "You can search me." That's in the video. That's a voluntarily consent to search. Then also, and furthermore, once he's presented with the shard of methamphetamine, he could have said no, but he didn't. He said, "No, I don't have nothing to do with that. I've already been down that road." And he volunteered all of this information and then said, "You can search me again." And then they did, and that was what was found. Aside from just the consent multiple times, you then also have the fact that the officer, as they testified, reasonably believed that the defendant had to have known and exercised possession, control, dominion, and knowledge over the methamphetamine shards that were found exclusively in his seat, not anywhere else in the vehicle. Given this, the state would request that this court respectfully deny this motion to suppress. Thank you.
Yes, sir. I want to first address two of the cases that the state cited. The State v. Robinson, the 27th Southern 3rd 137, the 5th DCA, it's extremely important that we point out that the defendant was read Miranda. So he was taken out of the car once they found narcotics. He was read Miranda. Then he confessed. Then he was arrested. That's what it says. Post Miranda, he confessed to the drugs. They had both of them there. He confessed, and they only arrested him after they read him Miranda. And he confessed to the drugs in the car because it's constructive possession. With his confession, post Miranda, that is why he was arrested in that case. And it says that more than once, and it says when it talks about the lower court's ruling, it makes a point to say he admitted, post Miranda, he admitted to the cocaine, and the deputy said that's why he was the only one who was arrested. That's how they had probable cause, because he admitted in that case, which is not the situation in this case. They said they had probable cause because there were white shards on the seat. In the Upshaw case, Mr. Upshaw was arrested not based on a search of his person. At first, it wasn't because they got him out of the car and they just searched him. They patted him down, they felt something in his pocket, and that is how they got into his pocket, because they felt something that they suspected of drugs in his pocket, and then that's how they searched him. And the court upheld that search. That's not the same thing as this case at all, not even close. When the state keeps arguing, well, because they found drugs on him, that confirms what they thought, I don't think that's relevant. The issue is whether or not, when they started to search him, did they have probable cause to search him? Or consent, in this case. The state's arguing consent. But I would like the court, I like to point out, when he says in that video, when Officer Trujillo tells both of the people, hey, I'm looking on the ground, you guys both look on the ground, see if there's anything on the ground, he's talking to them. Mr. Dawson says he consents and asks, you want me to take off my shoes? What do you want me to do? You want to take off my shoes? He said, no, I'm just telling you that there's stuff on the ground. Officer Trujillo is the one who searched him. Officer Trujillo didn't believe that was consent. He testified that Dawson consented after I started searching him. I was in the he said, I was in the process of searching him when he consented. So when the state says there's a break in time, there's no break when Sergeant Chisholm comes up and talks to him. Trujillo's actively searching him when Sergeant Chisholm comes up to say, hey, look what I found in the vehicle. And then he makes the comments that he's made. But keep in mind, Judge, he was never in Miranda. So he's being talked to, he's being questioned without Miranda. He's not free to go. I mean, it can't even be more clear that none of his statements at that point would be admissible when he wasn't read Miranda. They admitted he wasn't read Miranda. They said he wasn't free to go. The state points out in Brown that it's not the same here. It is the same. It's absolutely the same. Priestley's the same as well. And in Priestley, you got a situation where the person's sitting on cocaine and there are meth seats and marijuana seats throughout the car. In the driver's seat. What's the difference in these two cases? I do have a copy of Priestley, Judge. Thank you. And Brown.
What's the site for Priestley?
Sure. What the state has argued today, Judge, is he's closest to the drugs. He gets in the car, it's dark outside, can't even prove he can see the stuff in the car when he gets in, because the officer actually uses a light to see inside the car. Yes, sir.
So, Ms. Quigley, you believe that in Presley, the cocaine located in a scene on the driver's side of the front bench seat of the car is the same thing as sitting on?
Yes, sir. I think it's the same thing as far as we're talking about in a seat. This is on the front part of the seat in this case, right? It's from the front edge of the seat. And this is on it's still in the seat. It's still proximity. And if you look at Brown on page 2 of the printout at the bottom, it states, it comes down to whether or not, without officer's knowledge at the time they conducted the search of the defendant, where the marijuana seeds are present on the floorboard and on the front seat where the defendant was sitting as a passenger, or riding as a passenger. It states this, and I asked Officer Chisholm these questions too. It stated the officer had no knowledge of how or when the marijuana seeds were brought into the vehicle, and had no knowledge that the defendant was aware of the presence of the marijuana seeds. It says, under these circumstances, a man of reasonable caution would not be warranted in believing that the defendant possessed marijuana. And they said that the order denying the motion to suppress was erroneous. In this case, Sergeant Chisholm testified, I don't know what knowledge he had. While he says that anybody should have known if they got into a car that it's meth, he can't say how long the defendant was in that car. He can't say if it was in the way the defendant got into the car. That's why it's constructive possession. It's not in his pockets or it's not in his hand. You have a situation where you search a car and you see shards, and you're here to say that everybody should know that that's meth on that seat, and they can't prove that. To say that everyone who gets in that car should know that as meth, that's impossible. You can't say it wasn't in it when the defendant got in the car, based on what you know until he searches. That's what we're dealing with. What did the officer know when he said he had probable cause? And he said he had probable cause when he saw it sitting on the seat. And he used a light to see that. And he said he admitted to that. So we're talking about at night in a dark car, the defendant's a passenger. The officer can't tell us when he got in the car. The officer can't tell us if he had knowledge of the drugs, and he testified to that. I don't know what he knew. That goes to the heart of the probable cause for that search. Sergeant Officer Trio said he clearly didn't believe there was any consent before he searched him. He said the consent was given while I was searching him. He had not been read Miranda at any point at all. And we didn't see it on any of the videos. And they all admitted they didn't read a Miranda. So any statements he made while they're talking to him should not be admissible because he wasn't read Miranda. They chose not to. And I believe it was, I think I handed it to you already. A Bollinger case about the handcuffs. They talk about the fact that there's no basis to handcuff them in a situation where, and the handcuff alone would be an illegal detention because at that point they haven't shown any basis. It says she had not shown any basis to show that she was a danger and that because she was handcuffed and then consent was given, that that consent would not be valid, and the state has the burden to show that the consent was. And I don't think they've done that. But I don't believe that that's really the biggest issue because I don't believe there was consent given. He wasn't read Miranda at all. The consent that the officer said, that the officer who searched him says he gave him, specifically said it was after I started searching him. Yes, he did consent, but after I started searching him. So the defense would ask that the evidence after he was searched be suppressed.
Ms. Dudley, any case law, any authority that shows when the court can find or how the court can find knowledge on the part of a defendant regarding the presence of drugs? Is there anything that says
I think what it comes down to, the officer has to show how the person knew knowledge. The issue with constructive possession, I think the cases I provided do show that to some extent, but the issue with constructive possession is and it's the vehicle that's occupied. So they have to be able to show, and I think in our case, it basically goes down to a reasonable person to believe that the person had knowledge, or the officer's knowledge, is what the case law says, and I think I provided it. And I can give you a couple cases that deal with probable cause, just probable cause alone.
So
that I have cited,
the officer has to reasonably believe that the
defendant knew.
that those were the drugs.
Yes. But in our case, Sergeant Chisholm said I can't say what he knew. And to say that every person who gets into that car should know that that's meth, we're talking about just little pieces of white something on a seat. He even says, well, I can't say what he knew. And that shows he didn't have reasonable belief to say that this defendant knew what was on that seat. We're talking, it's dark outside, and he has to use a flashlight to see it. I think that's what matters in the case. I do have some cases on probable cause failure, which I did cite in the motion.
So, Mr. Gomez, why wouldn't it be required for the officer to have testified, I believe, at the time of the search, I believed that the defendant knew that these were the drugs?
I think the officer did testify that given the location of the methamphetamine, he testified that he would have known that it would have been, that any person getting into that car would have seen that methamphetamine there. So I think given the fact that, and it's not knowledge, it's knowledge of the illicit nature, but it's the fact that he's sitting on it, and the cases that I've cited have stated that in no case that I cited where they ended up denying a motion to suppress on similar grounds did the court ever dive into whether or not the defendant knew that it was methamphetamine or knew that it was cocaine. It was the fact that the defendant knew that they were sitting on it. And in this situation, when you open up the door there and the front seat is covered with shards of methamphetamine, and only the front seat was covered with shards of methamphetamine, the defendant was just taken out of the passenger seat. That is what the officer used to establish that he had knowledge of the presence of the methamphetamine that was there.
Thank you. Mr. Dawson. So, and I'm not talking to you to elicit anything. There's no upside to you saying anything, and I'm not seeking that. But this is your case and the state's case, so I want to address you. I believe that your attorney is correct as far as being under arrest or detained. I don't think an officer can just put you in handcuffs immediately when they pull you out of the car. They certainly can pat you down and look for firearms, and they did that, and then they stopped. But then they put you in handcuffs, and then later they patted you down again, and then they did it, well, not patted you down, then later they searched you, and then later they searched you again. So the dispositive part, the part that the reason why I make my ruling isn't because I believe that you gave consent, a valid consent for the search. So that's not my focus. My focus is really knowledge. I do find dominion and control because from the limited evidence that I've received today, and again, I really don't want you to say anything, but I'm saying you because you're the defendant. But I do find that you were sitting on those illegal drugs. So I do find dominion and control. That was why I really focused on knowledge, because that's what I make my decision on. I think that is dispositive. The consent, the detaining, the Miranda, all those different things. The ultimate discovery doctrine certainly comes into play with what was physically on you versus what was in the car. The court does find that you had knowledge, dominion, and control over those substances. So that did give the officers the right to arrest you, because I find probable cause for that arrest. They didn't have probable cause to search you at that point, but under the ultimate discovery doctrine, they were going to arrest you anyway because of the probable cause for the knowledge, dominion, and control and therefore their finding of the drugs on your physical person. Based on all that, the amended motion to suppress respectfully is denied. So will I see Mr. Dawson on July 10th?
I believe that's what it said. I don't think it's set. I don't think he's set yet, if I'm correct, but I'm not sure.
Yeah, we had said it because this was I think we both agreed it was positive, and so we hadn't said it. I think we'll want to resolve it in the next cycle.
So do you want pretrial on July 10th? Do you want it on September 11th?
I'll leave that up to Ms. Dudley.
Can we get September, Your Honor?
Yes, ma'am. So September 11th will be the pretrial. We'll be looking at going to trial on September 26th for October.
If the state would stipulate that the motion is dispositive, that the motion was dispositive?
Yeah, I mean, yeah.
I just need it on the record for appeal purposes.
Yes, ma'am. The two exhibits that were admitted, A and B. And again, the lady that is on Zoom, I have no idea what she's here for, so I'm ending the Zoom. Thank you. We're adjourned. Thanks, Sean.